Hi, I'm Miriam Ackerman. I'm an attorney at the ACLU of Michigan and one of the attorneys in the Hamama Viaducci class action lawsuit regarding Iraqi nationals.
Hello, I'm Elaine Lewis, and I'm a legal fellow at the ACLU of Michigan, involved in the Hamama case.
So we're here today to give our class members an update on what's happening in the Hamama case. And I wanted to just start off by saying that I hope that in these really uncertain times, you're home with your families, you're safe, you're healthy, you're taking care of yourselves. We know that this is a time of great uncertainty for everybody. Unfortunately, today we have some news that will make things more uncertain for some of you. We want to tell you what's going on in the Hamama case.
What has happened in the case?
So if you remember, back in January, the Sixth Circuit Court of Appeals, in a 2-to-1 decision, said that Judge Goldsmith didn't have the authority to do a class-wide order regarding the release of individuals from detention, or class members from detention, that it couldn't be decided for everybody together at the same time. We went to the back to the Court of Appeals and asked the full court to hear the case. It's called an en banc petition. Basically, it means that all the judges, all the active judges on the court will hear the case, and we asked the full court to hear it. They, however, yesterday turned us down and said that they were not going to hear it, and what that means is that the Sixth Circuit decision saying that Judge Goldsmith didn't have the power to do what he did is going to go into effect. And that decision will go into effect on our April 23rd. So basically what that means is that as of April 23rd, class members will no longer be protected by Judge Goldsmith's orders that relate to detention and redetentions. And so we wanted today to explain what that means for you in terms of what could happen with detention and redetention for individuals in the class. I think it's really important for people to understand that what the Sixth Circuit said had to do primarily with whether or not Judge Goldsmith could do what he did on a class-wide basis, so for everybody at once. That doesn't mean that you don't, as an individual, have individual claims. If you do get redetained, and it's not clear whether you would get redetained, but if you were to get redetained, doesn't mean that you don't have claims for release. It means that there's certain types of class-wide relief, what we've been doing for everybody at once in the Hamama case, that we can no longer do. The other thing I think it's really important to understand is that it's really, really important that if you want to do something in your individual case, you please ask your immigration attorney, if you're going to try to do something around detention, if you get redetained, that you please have them coordinate with us, because the relationship between the class case and any individual case is pretty complicated. We want to make sure that you don't lose any protections that you have in the Hamama case. So I just want to say that at the outset, it's really important to coordinate with the Hamama legal team if you're going to try to do anything individually. I also think it's really important for people to understand that this does not mean that you will necessarily get redetained. It does not mean that you don't have claims if you were to get redetained. What it means is that we're at another step further along in the lawsuit, and that we now have to be thinking again about what's the best way to protect you on the detention side.
Will ICE redetain class members during the pandemic?
You know, it's a really important question, and unfortunately we don't have a good answer to that. So the situation is really, I mean, it's an unprecedented situation in this country. We don't know if ICE will detain Iraqis during this pandemic. Right now, obviously, ICE is being sued all over the country to get people out of detention because of the dangers of the pandemic. It's obviously very difficult for ICE to remove people. We've reached out to the government. We hope that ICE will make it clear that they're not going to be redetaining people, but we simply don't know the answer to that. What ICE has said publicly is that they're going to focus their enforcement efforts on public safety risks and individuals subject to mandatory detention based on criminal grounds, and that they will exercise discretion to delay enforcement actions until after the crisis or use alternatives to detention as appropriate. So unfortunately, we really don't know the answer to what ICE will do during the pandemic, but obviously it changes the situation on the grounds and is a really important reason why we call on ICE not to be redetaining people. It would be really terrible if they did. It really obviously affects what happens to people and makes detention a much more dangerous thing than it already is.
How can people find out whether or not they can be redetained, or if they're redetained, whether they can get released again?
So we're going to go through that in more detail, but as a broad sort of piece of background, first of all, you should speak to your individual immigration attorney because everybody's situation is a little bit different, and so you need to get advice that's specific to you in your individual situation. But basically, there's sort of three things that affect the analysis in your individual case. The first of those is, what's the status of your immigration case? Where are you? Do you have a final order, or are you pre-order, or have you won your immigration case? So basically, generally, you have a final order if you've not filed a motion to reopen, or if you lost your motion to reopen, or if you got your case reopened, but then you lost your case and you either didn't appeal it or you lost it at the Board of Immigration Appeals. So generally, that's when you have a final order. So that's one type of place that you are in the immigration system. Another is if you're pre-order, if you've reopened your case and you're waiting for a merits hearing, or you are on appeal in that case before the Board of Immigration Appeals. So then you'd be pre-order, so there's different rules that apply. And obviously, if you've won your case, you're in a much better situation. So that's sort of the first bucket of things, like where are you in your immigration case? The second thing is if you're pre-order, so if you've won your motion to reopen and you're still litigating on the merits of your case, and you're waiting for a decision either from the immigration judge or from the Board of Immigration Appeals on the merits, then you're pre-order. And pre-order people, some people are in mandatory detention, and other people are not. There's also a group of individuals who are called arriving aliens. Your immigration attorney would know if you fall within that category. And those individuals, depending on where you are in those different parts of the immigration law, that affects what detention law applies to you and what will happen going forward here. The third factor is how you got released. So some people got released under normal, regular immigration bond hearings, not very many, but a couple. A lot of people got released under what are called Hamama bond hearings. Most of those releases were in early 2018. So they're after we won that ruling from Judge Goldsmith granting bond hearings. A lot of people got released then. And then there are people who got released under what we call the Zidvitas order. There's a Supreme Court case that basically limits the amount of time people can spend with the final order in detention. We won a ruling from Judge Goldsmith that released, a lot of people were released under that in late 2018. And so there's three different ways basically that people would have gotten out, and which way you got out also affects what will happen going forward. So you can see there's a bunch of different combinations of those different factors that can apply, and that combination affects what will happen in your case, which is why it's really important to talk to your immigration attorney. The other thing I really want to emphasize is that your history of reporting really, really matters, because if you have been doing a good job in terms of reporting when you're required to report, showing up, complying with your bond conditions, doing what you're supposed to do, judges are going to take that into account. Immigration judges, if they're looking at bond again, a federal judge, if you're trying to get release, if you were to get redetained, all of those things, your history of reporting is really important. So we really encourage you to make sure that you're complying with your orders of supervision, your bond conditions, because that will affect, if you do get redetained, we're not saying you will, but if you were to get redetained, that will make a difference.
Is there a chance that ICE would consider your reporting history in deciding whether or not to redetain you?
I think that's actually quite possible. We don't know what ICE will be doing, but if someone has a really good reporting history and is showing and is complying, and your deportation officer says, you know what, there's no point in putting this person in detention right now because we know that they're going to show up and report, that could be a factor in whether ICE decides to put you in detention. We simply don't know, but it's certainly something that you would think they would be considering.
I know you touched on this a little bit earlier, but could you clarify whether or not people with final orders can be redetained?
Sure. So again, a final order is if you didn't file a motion to reopen, or you filed a motion to reopen and lost, or you've lost your immigration case, either before the immigration judge and didn't appeal, or appealed and lost it before the Board of Immigration Appeals. So then you would have a final order. And basically there's a Supreme Court case, again called Sidvitis, that says there are limits on how long people can be detained, and that's basically 6 months. And if it's longer than that, then the government's going to have to show that you're likely to be removed pretty soon. And that was the basis of Judge Goldsmith's release order at the end of 2018. Now, what the Court of Appeals said about that release order is that Judge Goldsmith couldn't do it for everybody in the class. But the Sidvitis case, those limitations on how long people can be detained, those apply to you individually. And so that is a pretty strong argument with respect to whether or not you can be detained if you have a final order. Whether or not, so we think there are some really strong arguments why you shouldn't be detained under these circumstances. And if you have a final order, we intend to move forward with those. We hope that ICE will take those very seriously. But obviously, we don't know whether we'll have to litigate those, whether ICE will simply not redetain people, but that's basically the legal framework that applies to people with a final order.
Can people be redetained if they're pre-order?
Okay, so with pre-order people, as I mentioned before, there's some people who are bond eligible and some people who are not. It depends on whether you're arriving alien, or what's called an arriving alien, or mandatory detention. So let's start off with the groups for if you're not an arriving alien and you're not subject to mandatory detention. So what that would mean, if you're not in one of those groups and you're waiting, you've reopened your case and you're litigating the merits of your case and you don't have a final decision yet, then you would be eligible for a regular bond hearing under regular immigration law. So some people under immigration law get bond hearings and some people don't. Just like everybody else in the immigration system, if you're eligible for an immigration bond hearing, you would be able to get an immigration bond hearing. Now, a lot of people had Hamama bond hearings already and got out on Hamama as a result of a Hamama bond hearing. Those bond hearings had different, they were better, so to speak. They had better standards. And so the government could come back and say, hey, we want to redo. We want to redo under these other standards that are harder to meet. I don't know whether they would really do that. There's obviously there's a lot going on with the pandemic. It's very hard to hold hearings right now. And if you've had a good history of reporting, and again, your reporting history really matters here. If you've had a good history of reporting, I don't know why they would want to do another bond hearing. It's possible that they would. So for people who aren't under mandatory detention or who aren't arriving aliens, if you have had a bond hearing and you're doing well and you got out on bond, you're in a pretty good position, I would think. Again, I don't want to speculate about what they're going to do, but legally you're entitled to a bond hearing under those circumstances. There are some people in that group who got denied bond and later got out under the Zidvitas order. And for those people, you should consult if you do get redetained, you should consult your immigration attorney about getting another bond hearing under those circumstances.
Can people be redetained if they've won their immigration case?
Actually, let me get through one more thing on the people who are arriving aliens or are mandatory detention. So, as I said before, if you're pre-order, there's sort of the group of people who can get bond hearings, and then there's a group of people who can't get bond hearings under regular immigration law. So if you're considered an arriving alien, or if you're considered a mandatory detainee, if you had a bond hearing, the only reason you got a bond hearing in the past was because of the Hamama case, right? And since then, the Sixth Circuit has now said that you can't get, Judge Goldsmith was wrong on a class-wide basis to order those kind of bond hearings. The Sixth Circuit hasn't made a final decision on whether people who are in prolonged mandatory detention are able to get bond hearings as an individual, not as a group, not as a class, but as individuals. If you're in that category and you get redetained, you need to talk to your immigration attorney to work with us on the Hamama legal team about the best strategy in your particular case. It's complicated, but we have a number of different arguments that we think are important, and that we think that you shouldn't be detained. Whether a court will agree with us, we don't know, but there are certainly arguments that your detention would be illegal.
Can people be redetained if they've won their immigration case?
So if you've won final immigration relief, if your case is completely over, you can't be redetained absent some major change in circumstances like getting a new criminal conviction. So please stay out of trouble. Winning final relief in your immigration case is the only sure way to prevent detention. Now, one thing I should say about that is if you've won withholding or deferral, it's possible you could be redetained if the government were trying to figure out whether they were going to send you to another country. Like, say you were born in one country but your citizenship is Iraqi and they're trying to deport you to that country, or certain circumstances where they're trying to figure out, can we deport you someplace other than Iraq? So that could happen, but talk to your immigration attorney if you're concerned about that particular scenario in your particular case. But generally, if you've won immigration relief, you can't. If you're done with your case, you can't be redetained. If you've won and your case is on appeal, it's possible that ICE could redetain you.
Can people be redetained if they have serious health issues?
So obviously, detention is a really terrible place for anybody with serious medical health issues. And now with COVID, it's a really, really dangerous place for people with serious health issues. ICE is claiming that it's considering people's health conditions in making detention decisions during the pandemic. But we know that there are many people with serious health conditions who are in detention whom ICE is not releasing. Across the country, the ACLU, many other groups are going to court to try to get people released who are medically vulnerable, who are in detention. Some of those cases, immigrants have been released. In other cases, they haven't been released. It's all happening very fast as we speak. If you have serious medical conditions, you should get information together about your conditions, like medical records or a statement from your doctor. You should put those papers in a safe place and make sure that your family members know how to get, where those papers are, and that your immigration attorney knows how to get those papers. You should also make sure that your immigration attorney, as well as your deportation officer, know what your medical conditions are. So those are important steps that you can take to try to prevent redetention based on your medical conditions.
What kinds of medical conditions should people be getting information about? Is there a way of finding out which kinds of conditions make you more vulnerable to COVID-19?
Sure. So I would go to the Center for Disease Control website. There's a listing there of conditions that make people particularly vulnerable. Those are the ones that ICE is going to be most concerned about in terms of taking people back into custody. If you fall into those conditions, one of those conditions, that would be most important. But I'd encourage you, regardless of what the knowledge about COVID is evolving all the time. And we're learning more, and scientists are learning more and more about what puts people at greatest risk. And so even if you don't fall technically within those guidelines, I'd encourage you to get information about your medical history.
What are the next steps in the Hamama case?
So, as I said before, under the Sixth Circuit decision, Judge Goldsmith cannot order what's called class-wide injunctive relief. Basically, that means he can't order the government to do something for everyone in the class. But there's other kinds of class-wide relief that he does have the authority, we think, to order. Things like declaring what your rights are, different types of relief. And so we may be able to use some of those other avenues going forward. We're looking at what the best options are. In addition, there's the question, as I said before, the fact that you can't get something on a class-wide basis doesn't mean that you can't get something on an individual basis. So if you're redetained, you might have individual arguments about why you should get released in your individual case. Again, we really encourage you to have your immigration attorney work with us before you file something, because if you file things, it could mean that you lose, individually, it could mean that you lose the protections of the Hamama case. And that's a really important and difficult decision. And we're trying to make sure that that we coordinate with your immigration attorneys about this going forward. The other thing that we're going to be doing is reviewing the Sixth Circuit decision to determine whether or not to ask the U.S. Supreme Court to look at the case. We have asked the U.S. Supreme Court to take the first part of the case that had to do with deportation. But regardless of, as we're talking about that within the legal team and assessing the best strategy, regardless of that, that's not gonna affect the fact that Judge Goldsmith's orders are not going to be in effect a week from now.
What is happening now with deportations to Iraq?
So with deportations, under the Hamama case, the Hamama case does not prevent deportations. The Court of Appeals said over a year ago that Judge Goldsmith didn't have the power to stop your deportation. And that's the part of the case that we've asked the U.S. Supreme Court to hear. So whether you get deported depends entirely on what happens in your individual immigration case. Now, the pandemic is obviously making removals really difficult. It's difficult to, there's, not commercial flights, international borders have been closing down, governmental operations have been disrupted in the United States, in Iraq, and countries where there would be you'd need to get transit visas. So it's very, it was very, very difficult before, but at the and it's even more difficult now. But legally, it's, we don't know how this will evolve. I will say that you can't be deported if you've won your motion to reopen and you've not yet gotten a decision on your reopened case. So if you're pre-order, you can't be deported. If you have you can, and the most, at least the best way not to get deported is to win your immigration case. If you win your immigration case, you can't be deported to Iraq. If you win withholding or deferral, it's possible that the government would try to deport you to another country. Obviously quite difficult for them to do that often. But if you win your case, that's the way to make sure that you don't get deported to Iraq. Now, you can be deported if you have a final order of removal. We talked about what that means. You have an unexpired Iraqi passport, or Iraq has issued travel documents for you, and you don't have a stay of removal from an immigration judge, the Board of Immigration Appeals, or the Court of Appeals in your individual case. The other thing I would say, just in terms of issuance of Iraqi travel documents, we don't know exactly what's going to be happening now, particularly with respect to the pandemic, but you shouldn't assume that Iraq will not issue travel documents for you. Typically, that has happened as after consular interviews, and those have typically happened when people are in detention. You should be talking to your immigration attorney about what it would mean if travel documents were issued in your case.
Miriam, you were breaking up a little bit. Do you think you could repeat that last part that you mentioned?
Sure. So I would just say that so you can be deported if you have a final order of removal, if you have either an unexpired Iraqi passport or Iraq has issued travel documents for you, and if you don't have a stay of removal from an immigration judge, the Board of Immigration Appeals, or Court of Appeals in your individual case. And in terms of Iraq issuing travel documents, we don't know what's going to be happening now in light of the pandemic, because obviously that's really disruptive to all sorts of things. But you shouldn't assume that Iraq won't issue you a travel document at some point. That's typically happened as a result of consular interviews, and consular interviews have typically happened when people are in detention. So if you've had a consular interview, you should talk to your immigration attorney about what it would mean if Iraq had travel documents for you, because that's the step in the process that precedes the issuance of travel documents.
Can people get immigration relief in Canada if they've lost their immigration case in the United States?
So we're not Canadian immigration attorneys if you don't have a license to practice in Canada, but we do encourage people to look at Canada as an option and talk to Canadian immigration attorneys if you have lost your case or are concerned about losing your case in the United States. Canadian immigration law is very different from the United States, and you may be eligible for relief there, even if you're not eligible here. We have a lot of information, links to information, I should say, more than a lot of information, more links to information about that, as well as information about how to get a list of Canadian immigration attorneys that are on our website. And our website also has we've posted an explainer that goes through in more detail what Elaine and I have just been talking about today, and explains the different information that we've gone through. And we encourage you to look at that and read through that, because I know it can be hard sometimes to follow all of this when someone's just talking at you.
So if I was a Hamama class member who was interested in seeking immigration relief in Canada, and I loaded up my bike and biked across the bridge to Canada, is that a good idea?
You should always talk to a Canadian immigration attorney and make sure beforehand. If you just appear at the border, you are likely to be apprehended by on the U.S. side before you cross. So you should definitely always talk to a Canadian immigration attorney. First, find out whether you're eligible for any kind of relief there, and then work out a plan for how to cross the border by working with a Canadian immigration attorney.
How can people make sure that they know what's going on in the Hamama case?
So when major developments happen, we will post something on social media, on Facebook. We will do a video recording or a Facebook Live posting, depending on sort of how the technology is working, which is a little more complicated now with the pandemic. But we will put that information up on social media and on our website to make you aware of it. You can also send questions to our Hamama email address, which is Hamama, HAMAMA, at ACLU, ACLU-mich.org. Again, that's Hamama, Hamama, at ACLU-mich.org. You can send questions there. We can't provide you detailed individual immigration advice because that's what your individual immigration attorneys are for. So you need to be asking them about how all of this applies in your individual case. We can't do that for everyone. But if you have general questions or need to get in touch with us, that's the best way to do it. We also try to reach people by mail and email. If we don't have your contact information, please send it to us. Our website includes the end of the description of what we've just been talking about. The explainer, there's a form for people to fill out. If you haven't sent that yet, or if your address information has changed, please send us an updated form. Please send us a form so that we know how to reach you, know how to reach your family members if you do get detained, and send that back to us at the ACLU of Michigan, 2966 Woodward Avenue, Detroit, Michigan, 48201 is the address of our Detroit office where you should send those forms with your information, or you can email them to us at the hamama@aclumich.org email address. So I want to thank you all for listening. I know this is not good news. It's difficult news, and this is a very difficult time in this country. You guys have been fighting this now for a long time, as have we. We are going to continue to do what we can under these circumstances I think that the good news is that as a result of this case, many of you have been able to win your immigration cases, fight your immigration cases, be home with your families. That's where you belong. That's where we want to keep you. There are definitely paths going forward. We don't know what ICE will do, and there are lots of ways to continue to keep fighting, and we will continue to do that. We are certainly calling on ICE not to do any redetentions. We have no idea whether they will, and not everyone can be redetained in the first place. But we know this is concerning information to you. We want to acknowledge that, and we want to say that we're here with you. We're hopeful that, especially in light of everything that's going on in the country, ICE will recognize that where you belong is home with your family, where all of us belong right now. So please be safe, stay safe, and we will continue to be in touch and to fight for you. Take care.